Hello and welcome to the first in a series of podcasted lectures around the requirements for valid private express trusts and gifts. This particular podcasted lecture will deal with the area of express trusts and gift requirements known as the three certainties. To start with though, we're going to take a look at a number of different possible property transactions and try and draw out the distinctions as between them, particularly paying attention to gifts as opposed to trusts. There are a number of different ways of transferring property and, as can be seen from the slide, a number of different transactions that can take place to give effect to this. A gift is perhaps quite obvious as an example. I intend to give you some money, say £100. I give you that money in cash, delivery is effective, and you now have legal title to that money and are therefore free to do as you see fit with it, anything you want. A sale of property is similar in the sense that there is a transfer of ownership, but there is obviously an extra contractual element to it. But it is still just a transfer, albeit with an exchange of consideration for that. For example, you want my iPod and I ask you for £50 in exchange for that. You give me the money, I give you the iPod, and put in the simplest of terms, the contract of sale is complete and the transfer of legal ownership effected. Now, you may actually not want my iPod. I have quite an eclectic music taste, but it is predominated by Kylie, early Madonna, and a lot of musical theatre and show tunes, so you may not actually want to give me £50 for that. But for the sake of the example, let's just imagine that you did. A trust is obviously different to a gift or a sale, and we'll expand on the distinctions between trusts and gifts a little bit more in a few moments. However, as you are already aware, in the most basic of terms, trust property is transferred to one person for the benefit of another. So the trustee has the legal interest and the beneficiary has the equitable interest. I've also added loan just as another example of a possible type of property transaction, but very simply a loan is the giving or the granting of something, particularly a sum of money, to another with the expectation that it will be repaid, typically with interest, or returned. And you can see that this, again, is an entirely distinct arrangement from the other three property transactions already referred to. To expand a little bit more on the distinctions between gifts and trusts in particular, consider the following scenario. Gerald has been advised for tax reasons to pass on some of his wealth to his grandchildren. Harriet, who's 28 and settled in her career in marketing, and Ian, who's 18 and not sure as to his future path in life. He intends to benefit each of them to the value of £30,000. How might Gerald benefit his grandchildren given their different circumstances? Or what would be the easiest way to benefit the grandchildren? The simple answer is that a gift would be the easiest way. Give each of them £30,000, allow them to be free to do what they wish with that money. Now that might be suitable for Harriet, who's a little older, more settled, more mature, and might well be trusted to spend the money wisely. That might not necessarily be the case for Ian, who's less sure as to his path in life and is that little bit younger. He may well spend all of the money on fast cars, women and booze, or to paraphrase the late great George Best, he may even squander it. So in order to try and allay any concerns or anxieties that Gerald might have in regards to giving Ian complete control over the money, what device might you use instead? Well, this is where a trust shows its advantages over a gift, because you could use a trust, a discretionary trust, for example, some form of protective trust which might include conditions that Ian might have to complete a university degree or attain the age of 21 or some other contingency. So expanding a little further between outright gifts and trusts, there are clearly differences and similarities between the two transactions. Just to highlight it a bit more clearly, I want to give Dave £300, so I pass over that money in the form of cash. He now has complete control over that money. He can do what he wants with it. He can spend it on anything he likes. If instead of making a gift though, I wanted to create a trust, I would transfer the money to my chosen trustee and direct them to hold the money on trust for his benefit. The trustee holds the legal title, Dave has an equitable interest. So we've said that there are clearly both differences and similarities between the two transactions. Well, what are these? Well, the differences involve the intention and the similarities involve the transfer. In both cases, the actual transfer of property is similar, but with a different intention on the part of the transferor. In the case of a gift, the transferor intends the donee, i.e. the recipient of property, to have complete control over the property. In the case of a transfer by way of trust, the transferor intends to impose an obligation upon the transferee, i.e. the recipient of property, to deal with that property as they are instructed. In both circumstances, the subject matter of the gift or trust must be transferred in the correct manner for the transaction to be valid. As regards a gift, this is known as making a perfect gift. As regards a trust, this is known as constituting a trust. So the creator, the settlor, the donor must have done everything which is necessary to transfer the property in order to regard it as being perfect if it's a gift or constituted if it's a trust. We'll consider this issue in more detail in the coming podcast when we talk about constitution and formalities. But for now, let's move on to consider what we mean by an express trust. But what do we mean? Well, as the slide says, these are trusts which are brought into being by the deliberate act of the owner of property, and there is a separation of the legal and beneficial ownership of that property. We'll consider the case of Milroy and Lord again when we discuss constitution over the coming podcasts, but the important point you need to know for now with reference to express trusts is that there are two ways in which property can be vested in a trust for the benefit of a beneficiary. Either the settlor declares him or herself to be the trustee of the trust for the beneficiary and states the terms of the trust, or the settlor transfers the property to a third party, a named trustee or trustees, and instructs them how to hold it for the beneficiary. Express trusts are declared intentionally by the settlor. Typically, they will intend to settle specific property on trust for clearly identifiable beneficiaries to be held by appointed trustees according to the terms set out by the settlor. However, there are, as we will see, situations in which the settlor intends his or her actions without necessarily knowing that a lawyer would define those actions as constituting the creation of a trust. In such situations, the court will nonetheless find that an express trust has been created. More on this later though. So, what are the requirements for a valid private express trust? Broadly speaking, they can be placed under three heads. Certainty, which is in turn broken down into three components, which we'll come on to in a moment. Constitution and formalities. We'll consider the latter two of the three over the coming podcasts, but this particular podcasted lecture is concerned with certainty, or perhaps more accurately, three certainties. When talking about express trust, this is arguably how the requirement for certainty is discussed more commonly in any event. But what are these three certainties? Well, according to the judgment of Lord Langdale in Knight and Knight, there is a requirement for certainty in three areas in order for there to be a valid private express trust. The first of these is certainty of intention, and this is also sometimes referred to as certainty of words, but essentially it's a requirement for there to be certainty of an intention on the part of the settlor or testator to create a trust. It's better to think of it as certainty of intention rather than certainty of words, as sometimes there are no words to construe, only acts. So think of it as intention, although you will see it referred to in some texts as certainty of words on occasion. The second of our three certainties is a certainty of subject matter, or the trust property. And this is both as a whole and with regard to the beneficial interest in the property. Essentially, there is a need for clear description of the trust property itself and the respective interests of the beneficiaries. And the third and final of these three certainties is the certainty of objects. And by objects we mean the intended beneficiaries, and so this requires sufficient certainty in identification of the beneficiaries. I put a note here for sanity's sake the word certainty appears on the face of it to denote a general lack of flexibility. In our introductory sessions, we've talked a lot about how equity is this very flexible, responsive, creative jurisdiction and jurisprudence. And then the very next thing we talk to you about is formal requirements and certainty. And it sounds like it is very inflexible. Nothing, as you'll see, could be further from the truth. The courts have, and indeed still do, enjoy a great degree of flexibility within this area of law, although this discretion is obviously exercised within recognised boundaries. As we'll see, the judges often agree on the destination they wish to reach, but differ greatly on the best mode of transport available to them to arrive at that point. You should not therefore be surprised to discover that your viewpoint will, on occasions, differ from your fellow student, from textbooks, and also possibly with the teaching team for equity and trusts. Another note to be aware of is that it's a mistake to view each of the three heads as independent areas, i.e. certainty of intention, certainty of subject matter, certainty of objects. They are very, very much interrelated, and this is a factor which will aid your understanding of the approach of the courts when analysing decisions such as Re Golay's will trusts, which we'll come on to in the third part of this podcasted lecture. And as an example of that point about the interrelationship as between the three certainties, see the case of Missouri Bank and Rayner. Now in this case, the testator gave to his widow the whole of his real and personal property, and his will stated that he was feeling confident that she will act justly to our children in dividing the same when no longer required by her. Sir Arthur Hobhouse, delivering their lordships' judgment in the case in the Privy Council, said, "If there is uncertainty as to the amount or nature of the property that is given over, two difficulties at once arise. There is not only difficulty in the execution of the trust, because the court does not know upon what property to lay its hands, but the uncertainty in the subject of the gift has a reflex action upon the previous words, and throws doubt upon the intention of the testator, and seems to show that he could not possibly have intended his words to be imperative words." So note in this case a very clear link between uncertain subject matter and uncertain intention. The fact that the testator here hadn't clearly defined the amount of property which would fall to be held on trust cast doubt upon his intention, so a clear link between two of our three certainties there. So that concludes our introduction very generally to the requirement for certainty. In the next part of the podcast, we'll move on to consider the first of our certainties in detail, that is, certainty of intention. Hello and welcome to this, the second part of our podcasted lecture on the three certainties. In the first part, we considered a very general introduction to express trusts and distinguished them from gifts, and outlined in general terms the broad headings of certainty. We now move on in this part of the podcasted lecture to consider the individual certainties in a little bit more detail, and this part in particular is concerned with the certainty of intention. So, looking at intention in just a little bit more detail then, what do we mean by saying that there is a requirement for certainty of intention? Well, at a very basic level, what the court is looking for is a clear indication that the settlor or the testator had a very clear intention to impose an obligation upon someone to act as a trustee. And whether or not an imperative obligation is imposed is a question of construction. So we have to look at the language, we have to look at the actions of the settlor. And a trust only comes into existence if it is the owner's intention to bring one into existence. So it's necessary, therefore, to examine the words or the acts used by the owner, i.e. did he or she intend to impose trustee-like duties upon the recipient of the property, or indeed upon him or herself if he or she are to be the trustee. And according to the case of Wright and Atkins, and according to Lord Eldon's judgment in that case, the words have to be imperative. But since equity looks to the intent rather than the form, there is no need for any particular technical expression to be used in order to create a trust. In every case, it is a matter of focusing on the words used to establish whether or not the words on the whole can be deemed to convey the necessary imperative obligation. A trust, therefore, may be created without using the word trust, and likewise the use of the word trust does not validate the purported existence of a trust. As the quote from McGarry and Reed-Cayford on the slide indicates, it is well settled that a trust can be created without using the word trust or confidence or the like. The question is whether, in substance, a sufficient intention to create a trust has been manifested. It's not surprising, then, that the determination of this issue in particular has led to some controversial judgments. It must be understood, however, that a trustee is placed under an imperative, i.e. a must-do obligation, and that the duties of a trustee are quite extensive, and the courts will not allow this burden to be placed on the shoulders of an unwilling and honest individual. So many disputes have arisen in relation to wills, where the testator has used expressions such as "in the hope that," "in the desire that," or "it is my wish that." These and other similar expressions that make general requests and can be seen as potentially uncertain are termed precatory words, and we will look at some case examples of these in a few moments. But before coming on to look at precatory words, the question of certainty may also arise where there is no document to construe. In this event, the acts or words of the parties need to show a clear intention to create a trust obligation. As an example, see the case of Paul and Constance, where the parties were an unmarried cohabiting couple. Mr. Constance left his wife to live with Mrs. Paul. Mr. Constance had received a court award of £950 for an injury that he'd suffered at work, subsequent to which Mr. Constance and Mrs. Paul decided to set up a joint bank account. But after visiting the bank, they were advised that the account should be set up in the name of Mr. Constance alone, because the couple were not married, to save embarrassment. Note, this case was in the 1970s, so a very different set of prevailing social conditions and expectations could be expected at that time. And so the account was set up solely in the name of Mr. Constance. Therefore, Mr. Constance was the common law owner of the account. The £950 lump sum, which he received as his personal injury compensation, was paid as a lump sum into the account and formed the bulk of the money held in it. The couple also added joint bingo winnings to the account and used some of the money to pay for a joint holiday. But importantly, evidence was also adduced at trial that Mr. Constance had said to Mrs. Paul on a number of occasions, "This money is as much yours as mine." Constance sadly died, and his estranged wife sought to claim that the bank accounts belonged entirely to her husband and that it therefore passed to her as his widow under the intestacy rules. Mrs. Paul, however, counter-argued that the money was held on trust by Mr. Constance as legal owner of the bank account for both himself and for her as beneficiaries. Therefore, Mrs. Paul argued that the bank account should pass to her as the sole surviving beneficiary. The litigation was therefore the stuff of soap operas, the spurned wife fighting out against the new lover. The court ultimately held that Mr. Constance had in fact declared a trust over the money in the bank account. The reasoning was that A, their behaviour, and B, that the words "this money is as much yours as mine" manifested sufficient intention to show that Mr. Constance held the property on trust for them both. Furthermore, the couple had treated the money in the account as joint money, and that was taken as further evidence of intention to create a trust. I mentioned in the previous part of the podcast that express trusts can arise even when the settlor doesn't understand that their intended actions will be described by a lawyer and recognised in equity as creating a trust. This case is an interesting demonstration of this point in the law of express trust. The court held that this was an express trust, i.e. one brought into effect by the deliberate act of the owner of property, even though, in the words of the court, Mr. Constance was a man of, in inverted commas, unsophisticated character, who did not know he was creating a trust. I think this is a polite way of the court saying they didn't think he was the sharpest tool in the box. But put simply, you can create an express trust without knowing that there is a legal concept of a trust. Instead, the court will consider your conduct and your real, substantive intention in deciding whether or not you can be taken to have intended the creation of a trust. And in this case, the words, "as much yours as mine," were sufficient for the court to find such an intention here. So, Paul and Constance is a very useful illustration of the equitable maxim that equity looks to the intent rather than the form, because Mr. Constance himself had no idea that there was such a legal arrangement as a trust, but what he intended in substance was a trust, and therefore the court treated his actions and his words as manifesting a sufficient intention to create a trust, even though he didn't know there was such a thing as a trust. A further and similar example comes in the case of Rowe and Prance. In this case, Mrs. Rowe was a widow who had a long relationship with Mr. Prance. Mr. Prance purchased a yacht for £172,000 and registered it in his name. The yacht itself was renamed to incorporate both of their names, but the legal ownership of the yacht remained with Mr. Prance. His excuse or his explanation for not registering Mrs. Rowe as a joint legal owner was that she didn't possess a relevant certificate. Mrs. Rowe put her furniture into storage and divided her time between the yacht and a bed and breakfast. But importantly, Mr. Prance repeatedly referred to the yacht as ours or as our boat. And the judge held that this was enough to give Mrs. Rowe a beneficial interest, and very similar then to the case of Paul and Constance. The intention was what mattered rather than any particular form of words. The fact that he commonly referred to it as ours and then her belief that she had an equitable interest on that basis was sufficient to give rise to a trust. But the court is not always able to find an intention in such cases. And in the case of Jones and Locke, a father returned home from a business trip to Birmingham, and when he got back, he was scolded by his wife for not bringing back a present for his baby son. He got into a bit of trouble for not bringing anything back for the baby. And you can imagine, tired after a business trip, that the last thing he necessarily would have wanted was to have an argument. So he wrote out a cheque in favour of himself as payee, so he wrote his own name on the cheque. Then shouted to his wife, "Look you here, I give this to the baby," and thrust the cheque into the baby's hand, saying, "It is for himself." Now, the baby, being a baby, started to rip the cheque up, so the father promptly took the cheque back, and it was put with his personal effects. Now, sadly, he died a short time thereafter, and the issue arising here was whether a trust was created over the cheque, or rather the money represented by the cheque. And it was found that there was nothing to indicate an intention to create a trust in this case. The cheque was endorsed in his own name rather than in a third party's name. And of course, he died, he could not be a trustee of property once dead. And if he had intended a gift to his baby son, then he should have written the name of his baby son as payee on the cheque. So the gift wasn't perfected and no intention for a trust could be found. Express trusts can also arise informally, for want of a better description, i.e. without a document, in the commercial context. And two examples on this point, Recayford and the Don King case on the slide. In Recayford, a mail order company received advice from accountants as to the method of protecting advance payments of the purchase price or deposits for goods ordered by customers. They were in some financial difficulty and so wanted to protect their customers. The company was advised to open a separate bank account to be called the Customer's Trust Deposit Account, into which any future sums of money received for goods that had not yet been delivered to customers could be paid. The company accepted the advice, and its managing director gave oral instructions to the company's bank. But instead of opening a new account, a dormant account in the company's name was used for this purpose. And a few weeks later, the company's financial woes came to a head, and the company was put into liquidation. And the question in issue was whether the sums paid into the bank account were held upon trust for customers who had paid either wholly or partly for goods that had not yet been delivered, or whether they formed part of the general assets of the company and could therefore be gone after by their unsecured creditors. This was important as, if the case were the latter, the customers would have ranked merely as general unsecured creditors themselves and may well not have received anything, or may well have only received a fraction of what they had paid in. It was held in the case that a valid trust had been created in favour of the relevant customers in accordance with the intention of the company and the arrangements affected. The position remained the same even though the payment hadn't been made into the proposed new bank account and instead had been, on the part of the banking error, had been paid into a dormant account. The intention was clearly to separate that money from the general assets of the company, and therefore there was a trust. Also in the commercial context, I mentioned the case of Don King Productions and Warren, where Don King and Frank Warren, the two boxing promoters, formed a partnership agreement whereby they agreed to exploit agreements that they held with boxers in Europe for their mutual advantage. When one tried to opt out, the question arose as to whether the partners held the benefit of their management agreements on trust for the partnership. And Justice Lightman referred to poorly drafted agreements in his judgment, but did hold that their intention had clearly been indeed to hold the benefit on trust for the partnership, and he referred to this as a matter of business common sense with such arrangements. So you can see that trusts can arise relatively informally, provided that there is a manifest intention to hold property on trust. On the previous slide then, we were looking at situations where there may not have been a formal document, a trust instrument, or a will to construe, to have a look at the words and to try and get underneath their meaning. So we had to look more to context, to the surrounding circumstances, and to words and actions of the parties. Commonly though, there will be a document to construe, and as mentioned a couple of slides back, expressions that you might find in wills in particular that indicate a wish or a desire or a hope are termed precatory words. And so we return to that issue now. And there is a need to decide where there's a subtle difference between merely imposing a moral obligation upon a person who is the recipient of property and imposing formal fiduciary obligations on that person, such that they become a trustee over that property. As an example of what we mean, it's possible that as part of making a gift to someone, the donor will seek to impose a moral obligation upon them. When I give my nephew Dylan £5 to buy a book as a reward and say, don't spend it all on sweets, that doesn't make him a trustee of that money. Instead, Dylan's under a moral rather than an equitable obligation to use the money to buy a book rather than to buy sweets. And I know full well, of course, he'll buy sweets. Now, the expression used by the courts to distinguish between a declaration of trust and a moral obligation is to define the latter as setting out precatory words. And merely precatory words do not create substantive trust obligations. In older cases, they in fact did so. Precatory words would give rise to a trust. And this was influenced by the rule that an executor of a will, the person responsible for administering a will, was entitled to any undisposed of property. And so, in order to prevent the unjust enrichment of executors, the courts of equity, the courts of chancery, leaned in favour of finding a valid trust to stop the property going to the executor. But after the passing of the Executors Act in 1830, that rule was revoked, and therefore, because the executor would no longer get any undisposed of property, this meant the courts of equity were happier to adopt a stricter approach to precatory words. And as an example of this new, stricter approach to precatory words, see the case of Lamanimes. In Lamanimes, property was given to a widow by a testator to be at her disposal in any way she may think best for the benefit of herself and her family. Now in that case, the words "she may think best" were obviously a little bit vague, and it was held that there was no clear wording showing an intention to create a trust. The intention has to be imperative. And speaking of the historical position of imposing trusts commonly where precatory words, such as those in this case, had been used, Lord Justice James said, "I could not help thinking that the officious kindness of the Court of Chancery in interposing trusts where, in many cases, the father of the family never meant to create trusts, must have been a very cruel kindness indeed." Now the point that James is getting at here is the fact that trusteeship is onerous, as alluded to earlier, and the courts are unwilling to let an honest person shoulder that burden when it was never intended in the first place. And post the Executors Act of 1830, the courts were happier to adopt a stricter interpretation to precatory words to prevent such a burden falling unfairly on someone's shoulders. This next case is another useful example of a trust failing for uncertainty of intention based on the use of precatory words, and starts to show how difficult construction can be. However, remember the use of the words "in full confidence", as in a couple of slides' time we'll see how another case, using those very same words, ended with a different result, and we'll consider why that might be. But in Re Adams and Kensington Vestry, there was a gift to a widow, "to the absolute use of my dear wife, in full confidence that she will do what is right as to the disposal thereof between my children, either in her lifetime or by her will after her decease." And it was held in that case that there was no trust. The words "in full confidence that she will do what is right" is vague. It is an expression of hope, a wish, or a desire, but it does not impose a mandatory, an imperative, a must-do obligation on the part of the wife to divide the property between the children. So in that case, the widow took absolutely. So we've seen a couple of cases, Lamanimes and Re Adams and Kensington Vestry, which illustrate the strict approach which started to emerge as regards to precatory words, and how the court tended to view precatory words as only giving rise to a moral obligation rather than giving rise to a formal trustee-like fiduciary obligation. Now, a few slides back, we discovered how prior to the Executors Act of 1830, the courts were in fact quite willing to give effect to a trust based on precatory words. This of course had its root in that rule that the executor of a will was entitled to take any undisposed of property therein, and so the courts of equity accordingly leaned in favour of finding a trust to prevent the executor from taking property and being unjustly enriched. However, with the new statute revoking that rule, the courts were much more comfortable with stricter interpretation, and in Re Hamilton, Lord Justice Lopez did quite a good job in summarising the new, stricter approach, saying, "It seems to me perfectly clear that the current of decisions with regard to precatory trusts is now changed. The court will not allow a precatory trust to be raised unless, on consideration of all the words employed, it comes to the conclusion that it was the intention of the testator to create a trust." Now, bear in mind what Lopez says here. A moment ago I asked you to remember the words "in full confidence" being used in a different case with different results. So he talks here about looking at the whole of the words in order to find your reference point, in order to construe intention. And so we see in the case of Comiskey and Bowring-Hanbury, you'll see that the wording used here was "absolutely, the whole of my real and personal estate, in full confidence," so there's that wording again, "that she will make such use of it as I should have made myself, and that at her death she will divide it to such one or more of my nieces as she may think fit, and in default of any disposition by her will, I hereby direct that all my estate and property acquired by her shall at her death be equally divided among the said nieces." And despite the use of the words "in full confidence" here, Using the approach suggested in Reed Hamilton from the previous slide of looking at the whole construction, in this case it was held that there was a valid trust. This is not contradictory, however, to the Reed, Adams and Kensington vestry case earlier, as despite the use of in full confidence, it's the construction of the words as a whole that arguably distinguishes them. So let's just break this disposition down a little bit more to see what we mean by that. If the disposition had simply said, absolutely the whole of my real and personal estate, in full confidence that she will make such use of it as I should have made myself, and stopped there, then that would have been almost indistinguishable from Reed Adams. It would have been vague, it would have been an expression of a hope, a wish, a desire, and would very clearly have been precatory wording giving rise only to a moral obligation. But this disposition in Comiskey continues and says, and that at her death she will devise it to such one or more of my nieces as she may think fit. And you may still think, at this point, there's some degree of optionality here. It's who she thinks fit, she may devise it, so you might think there's some degree of optionality, and therefore you might still say it's arguably precatory because it's only in full confidence that she'll do this. However, this disposition continues further, saying, and in default of any disposition by her will, I hereby direct, and it's that use of the word direct that's crucial here, that all my estate and property acquired by her shall, at her death, be equally divided among the said nieces. So initially it might seem very similar to Reed, Adams and Kensington vestry, but looking at that later portion of the disposition, where there is a very clear direction, a very clear order, a demand, therefore imposing a mandatory, an imperative, a must-do obligation on the recipient of property, that it is actually distinguishable from Reed, Adams and Kensington vestry. There is very clear evidence here, looking at construing the words as a whole, that the settlor, the testator, intended for the recipient of property to be a trustee. Now, in relation to the law and express trusts, it's often the case that the final decision will turn on two factors. First, as indicated by the foregoing discussion, a very close reading of the wording of the trust document. But secondly, it also requires a consideration of the circumstances surrounding the creation of the trust. And in many cases, in many situations, the settlor will not have made his intentions clear, and therefore the court may look at the more general situations of the parties. So in relation to the two cases mentioned, Reed, Adams and Kensington vestry, and Comiskey and Bowring-Hanbury, perhaps one additional distinction beyond just purely the wording is the perception that in the former case, in Reed Adams, the mother is more likely to ensure the well-being of her own children, and therefore she could be trusted to take the property absolutely and beneficially while still providing for those children, a mother generally being inclined to look after her own children. Whereas, in contrast, in the latter case, in Comiskey, a widow might not be so concerned to see the well-being of her deceased husband's nieces, preferring to care for some other family members, or indeed herself instead. As Hudson notes, though, the law of trust is frequently to do with the passions, the greed, and expectations of ordinary human beings, and so therefore it can't always be reduced to rigid legal principles. And part of the beauty of equity lies in its ability to deal flexibly with individual circumstances, so not being bound simply by the use of the words in full confidence, but looking more broadly at the context of the individual case, and of course the wording as a whole. So based on the foregoing discussion, precatory words may create a trust, but it's the whole context and the whole of the wording which must be examined in order to determine whether or not there was a sufficient intention to impose mandatory trustee-like obligations, or whether it fell short of that and was merely a moral obligation. As to why this is important, the essence of a trust is the imposition of an equitable obligation, personal obligations in respect of trust property, upon the legal owner, i.e. the trustee, which requires that the trustee act in good conscience when dealing with that property in favour of any beneficiary who has the equitable right. So the trustee holds the property on trust, but this means that they have an extensive number of duties. Equity expects and indeed demands strict adherence to duty. Trusteeship is indeed onerous. Think back to the quote from Lord Justice James in Lamines about the officious kindness of the courts of chancery in interposing trusts where they weren't intended. Trusteeship is onerous, and so we have to make absolutely sure that a trust was intended in the first place, because the courts are unwilling to let that very burdensome role fall on the shoulders of someone when it was not actually the intention of the settlor or the testator in the case. So that's broadly then the first of our three certainties. I'm going to conclude this part of the podcast by showing you a visual representation of what we've been talking about, and to more clearly demonstrate the consequences of uncertainty of intention and why it happens the way it does. So, we have here a very standard magic triangle, which we will be familiar with from previous discussions. And this here is representative of a fully constituted, very standard trust, where we have the settlor, the original owner of property, transferring legal title to the trustee, but the equitable interest goes to the beneficiary. And the final limb of the triangle is made up of the personal obligations that the trustee owes in respect to the trust property as towards the beneficiary. With what we've been talking about in this part of the podcast, we've been discussing that limb on the right hand side, the personal obligations in respect of trust property. We need to be very clear that the settlor intended to impose those obligations upon the trustee. If the intention is unclear, then we remove one limb of the triangle, and therefore we have an incomplete magic triangle. And if there are no obligations owed by the trustee in respect to the trust property as towards anyone else, then it can't be said that the equitable title has passed to anyone else. And therefore, the equitable title has in fact instead gone with the legal title to the trustee. And so there is no beneficiary at all. But of course, it's artificial to describe a transaction as involving the transfer of legal title and equitable title as two separate things when they're going to the same person as a sole recipient. So instead, we would more properly describe that as an outright transfer. And instead of having a settlor and a trustee, we call these parties a donor and a donee, i.e. the previous absolute owner, and then following an outright transfer, the new absolute owner of property. And therefore, when a settlor fails to clearly specify an intention to create a trust, when they don't manifest an imperative obligation, then we don't have a trust at all. What we have is a gift. And so the consequence of uncertainty with respect to intention is that the property passes to the purported trustee, but as a gift instead of as a trust. That then concludes our podcast part 2, dealing with certainty of intention. In part 3 of the podcast, we'll be looking at certainty of subject matter. Hello and welcome to this, the third part of our podcasted lecture around the issue of the three certainties, a fundamental requirement for a valid express trust. So, in the first two, we considered the general overarching requirement for certainty, and in the last part, we looked at certainty of intention specifically. In this part, we move on to consider the second of our three certainties, that is, certainty of subject matter. Certainty of subject matter breaks down into two elements. Firstly, when creating the trust, the settlor has to identify the property as a whole to be subject to the trust clearly. As an example, settlers who want to create a trust over land must identify which land they mean. But this first sub-requirement of certainty of subject matter, in a nutshell, requires settlers to be very specific about the exact property that is to be held on trust. The second sub-certainty of certainty of subject matter is with regard to the beneficial interests. So the beneficial interests themselves have to be certain. It has to be clear what type of interest each beneficiary has and what shares they will respectively enjoy. We'll come on to consider certainty of beneficial interest as a kind of sub-certainty in a few moments, but first we're going to deal with trust property as a whole. Now, without certain subject matter, the trustee's job would be impossible. If they do not know what the trust property is, how can they carry out their duties to, for example, invest it? How can they administer the trust for the benefit of the beneficiaries and or distribute the trust fund properly if they don't know what the respective interests are? So it needs to be clear from the outset both that the property as a whole is very specific and that the beneficial interest is sufficiently clear for the trustee to be able to exercise their functions under the trust. Turning to deal with certainty of subject matter as a whole, i.e. over the trust property, then if the actual trust property is uncertain, then there is no trust. In such an eventuality, the property is simply held for the settlor or the testator or their successors. The situation we have here is that we were never able to identify the specific property or the proportion of property that was ever to leave the estate, and so it doesn't leave the estate, it stays with the originator of the property. If, however, this purported but failed trust has been attached to a gift which is already certain, then the donee takes that gift absolutely. The two cases on the slide provide useful examples. In Palmer and Simmons, an attempt to impose a trust over the bulk of my residuary estate was held to be too uncertain to create the trust. Note here, the uncertainty isn't to do with residuary estate. The residue of someone's estate has a precise legal meaning. At the point of someone's death, we are able to calculate what debts they owe, what legacies they intend to leave, and the residue simply refers to anything that's left over after those things have been paid out. So that has a precise legal meaning. The problem here, however, is around the word bulk. What does bulk mean? Well, colloquially, it's used interchangeably with majority. It's more than half, but could be anything up to just short of all. So that represented in percentage terms could be anything from 50.0001% all the way up to 99.99999%, or anything in between. And the problem for courts in a case like Palmer and Simmons is quantifying what's meant by the word bulk. It's such an ill-defined term that we can't be sure as to what it means, and it doesn't have a clear objective meaning. And so on the basis that it has no objective meaning, the court said it was uncertain. In Spranger and Barnard, we have an example of the other type of situation. Again, the trust property as a whole is uncertain, but there was initially a certain gift. So, in Spranger and Barnard, a testatrix left £300 in securities to her surviving husband for his sole use, and at his death, the remaining part of what is left that he does not want for his own wants and use to go on some trust. And you see the difference between this case and the former case is the fact that there was at least initially a certain amount of property that left the estate, the £300 in securities. The problem arose as to what the husband could do with that. It's for his sole use, and at his death, the remaining part that he does not want, that is uncertain. We don't know how much he would not want. There's nothing there to stop him using all of it. And this really shows a close link with certainty of intention. The fact that she imposes no obligation on her widower not to use it all, therefore means that she can't be said to impose an obligation like a trust obligation. And so in that case, the husband was able to take free and take it as an absolute gift. Whichever form it takes, the real question that needs to be contemplated is whether or not the trust property is capable of identification. There's no difficulty where the asset's clearly identifiable, but where it's not clearly specified or there seems to be an element of ambiguity, then the trust property will be uncertain. And in the standard case, like Palmer and Simmons, that means the transaction is void, i.e. negatory. But in a case where there's a gift in the first instance and then an attempt to engraft the trust on top of that, but that trust is uncertain as to its subject matter, then that will operate as a gift, and just the trust part of it will be void, i.e. negatory. So, just as a visual representation of uncertainty of subject matter as a whole, we have here our standard magic triangle that we should now be familiar with. And in it, the settlor transfers legal title in specific property to the trustee, equitable interest to a beneficiary, and the trustee has obligations. But if you don't clearly specify what property or what amount of property is to be held on trust, then you actually don't transfer any title in anything to anybody, and therefore the property remains entirely with the settlor. And the transaction is said to be negatory, i.e. void ab initio, void from the outset. The circumstance we were dealing with in the visual representation a moment ago is the standard situation where a settlor fails to specify trust property at all. But we did also see a couple of slides ago a separate and peculiar circumstance in the case of Strange and Barnard. That is where a settlor clearly defines an initial transfer of property to one person as a gift, but then tries to engraft upon that a further arrangement, so possibly for a later time, of a trust, but over an unspecified amount out of that certain whole. And so we now consider the rule in Hancock and Watson. And this rule derives from Strange and Barnard, and also a later similar case of Lassence and Tierney, and provides for a particular means of allocating property on death where a trust fails for this reason. And the rule provides that in circumstances in which property has been left to a legatee, that is just a person who is named in the legacy in the will, as an absolute gift, but subject to some trust which has failed, then the legatee takes the property absolutely. Note, for this rule to apply, the trust has to have failed on the issue of uncertainty in the subject matter of the trust, but with a certain whole of a gift to begin with. So as an example, suppose that a trust had left all of my money to John, absolutely, but so that any money that he didn't need would be held on trust for my cousin, Gillian. Now the trust for Gillian would fail for uncertainty of subject matter with regard to her share, as anything John doesn't need is uncertain. But the initial transfer of all of my money to John is clear, that is certain. And so the rule in Hancock and Watson would permit John to take all of that money absolutely, and to be free of any equitable or other obligation. Now this shows a very strong link between subject matter and intention, as discussed in Missouri, Bank and Rayner, which we talked about in the first part of our podcasted lecture on certainty. In essence, what actually happens here is that although the intention to give the whole to the purported trustee is clear, the exact amount that's to be subject to the trust is unclear, and therefore the court considers that this has a reflex action back on the certainty of intention. If you didn't specify how much was to be subject to the trust, then how can it be said that a trust was ever intended in the first place? Accordingly, it's dealt with in a very similar way to precatory trusts. So just as a visual representation of the foregoing, the rule of Hancock and Watson can be illustrated as follows. What we have in the first instance is a very clear transfer of legal title, at the very least, in property, clearly defined property, from the settlor to our purported trustee. What we also know is that there are possible personal obligations in respect of an undefined, uncertain amount of that total certain property that had gone to the purported trustee in favour of the purported beneficiary. So the question that arises is, has an equitable interest transferred to the purported beneficiary? But what the rule in Hancock and Watson says is that because you haven't clearly defined the amount of property out of that certain whole that's gone over to the purported trustee, then the purported beneficiary has no equitable title. You can have no equitable interest in an uncertain thing. And therefore we lose one limb of the triangle immediately. And that actually also then means we lose the trustee, so the beneficiary rather, get that straight, out of the picture. So we then also lose that limb of the triangle that deals with the personal obligations, meaning very much like with certainty of intention, the equitable title has gone with the legal title. It's gone to the purported trustee. But we know how that then is artificial to discuss in those terms, and so what we actually have is simply an outright transfer from the donor, previous owner, to the donee, the new absolute owner. And therefore, under the rule in Hancock and Watson, what we end up with is a gift rather than a trust, when the subject matter of the trust element is not clearly defined. So let's have a look at one or two case examples in respect of certainty of subject matter. And the examples we're going to look at are in respect of inter vivos trusts. Now, inter vivos is just a Latin term meaning between the living. And what we're going to consider is the orthodox approach that's been taken in respect of inter vivos trusts. So firstly, considering the case of Re London Wine Company. Here we had a company which logically dealt in wine, and customers would place orders for deliveries of cases of wine or of individual bottles, and they would then obviously supply them. This wine was stored in a warehouse. Now, unfortunately, the wine wasn't segregated into parcels for individual customers. It was just all together. And the company became insolvent. And so creditors were only entitled to a proprietary claim, i.e. one for a trust, if they could each show that particular bottles or particular cases had been segregated from the others and therefore held for them separate to the general assets of the company. If there'd been no segregation, then they couldn't see that that property was to be held on trust, and generally it would form part of the general assets of the company, and therefore the customers would rank as unsecured creditors and therefore might not be able to claim anything at all, even though they had paid money. And in the case, it was held that because there had been no segregation of the individual parcels for individual customers, then there was no trust. We can see application of Re London Wine in the case of Re Goldcorp. And this is a similar case, but arguably more complicated as it concerns different classes of claimant, but the principle is relatively straightforward. Here we have a company dealing in gold, and they used investors' money to acquire gold bullion. Now, again, they hadn't appropriated or segregated any specific parcels of gold to individual purchasers, and it was held again on the company's insolvency that there was no trust for the investors, as they ranked as general unsecured creditors on the basis that there was no segregation. In general terms, there is no reason why the orthodox approach considered here shouldn't apply equally to intangible property as it does to tangible property. And the general principle that is taken from these cases is that the rule revolves not simply around it being logistically possible to identify the property, but rather that the property itself has actually been segregated for the purpose of subjecting it to the trust arrangement. Indeed, so there is no reason in principle why it shouldn't apply equally to all types of property. And indeed, in the case of McJordan at the bottom, the principle was followed concerning money in a bank account. However, if we look at the case of Hunter and Moss, we'll see that a very different approach was taken by the Court of Appeal when dealing with purported trust over intangible property in the form of shares. Now, in this case, there was an oral declaration of trust over 50 shares out of a total that the settlor owned of 950 issued share capital. And these hadn't been segregated. The settlor did not specify which 50 out of the 950 were to be held on trust, but nonetheless, the Court of Appeal held there to be a valid trust, even though there was no segregation. And one interpretation of this decision is that cases like Re London Wine, which concerned physical tangible items of property could be distinguished because they concern chattels. Here, the property was intangible in the form of identical shares in a company. There is a degree of logic to this. Of course, it is said that each bottle of wine has a unique character. You'll hear people say things like, was 1996 a good year, for example? And therefore it would actually matter whether you parcelled off a particular case of wine or another case of wine for a customer. That would actually make a material difference. But having said that, gold wouldn't really specifically matter. If it was gold bars and it was all identically sized, that wouldn't particularly matter. But nevertheless, Re Gold Corp would indicate that actually you do need to segregate even in that situation. But Hunter and Moss says it takes a very different approach and says that intangible property doesn't really make a difference at all, because although yes, technically you might expect to segregate property, the first 50 or the last 50 are actually no different, or any 50 randomly taken from the middle. So it doesn't matter whether you have shares numbered 1 to 50 or shares numbered 901 to 50, they're identical. And the actual property isn't the share certificate, but rather the rights that the share certificate gives you. And so therefore, being intangible, it makes no difference. And that decision was also followed in the later case of Re Harvard Securities. Hudson notes some problems with this approach. Firstly, English property law requires there to be specific and identifiable property which is the subject of any right in the property. Thus, when considering rights in an asset like a share, which is intangible, shares are held on a register, and the property right involved here isn't the share certificate itself, because that's just a piece of paper, a piece of property which is distinguishable from other shares, but rather it's the shows in action that's represented by the entry on the register, the rights that gives you in respect to the company, because that's the transferable right between the shareholder, the register, and the company. In Hunter and Moss and Re Harvard, there were actually enough shares available to satisfy the claims. Thus, it was actually open to the Court of Appeal to decide that there had been a valid trust created because there were sufficient shares. Whereas in Re Gold Corp and Re London Wine, there were more claims than there was property to satisfy them. So Hudson suggests that the distinction, if there is to be one, should be made between cases where the legal owner of that property is either solvent or insolvent, and not between tangible and intangible property. Where the owner is insolvent, the principle known as pari passu requires that no unsecured creditor is advantaged ahead of any other unsecured creditor. Therefore, equity is equality in this context to apply the maxim. But where the owner is solvent, it would be possible to argue that it doesn't matter whether the property is sufficiently segregated. And therefore, Hudson suggests that that should be the basis for the decision, rather than making a clear distinction between tangible and intangible property. Note here the foregoing discussion refers to inter vivos trusts, that is, trusts as between the living. With testamentary trusts, i.e. trusts that are in someone's will, then they're treated quite differently, because an executor of a will has a general job to distribute the entire estate as between the legatees. And so even if a testator hasn't indicated which legatee is to acquire interest in which property, the executor can divide the general fund as between them and actually perform the job of segregation. They step into the shoes of the deceased. So note, any discussion here is to do with inter vivos trusts. Now Hudson is quite critical of the approach taken in Hunter and Moss on the basis of the foregoing. He also then looks at the Australian case of White and Shortall. You're invited to read his comments and critiques in more detail as part of your workshop preparation a little bit later in the term. But note, the general interpretation of Hunter and Moss is that it does in fact create a clear distinction for inter vivos trusts, lifetime trusts, as between tangible property which requires segregation, separating out for the purpose of subjecting it to a trust, and intangible property which requires no segregation. That is the general interpretation that's taken from the Hunter and Moss decision, although there are some critics of that, and you are invited, of course, as I said, to read those criticisms. So that generally deals with certainty of subject matter as a whole. As indicated earlier, though, subject matter actually breaks down into two elements, and the second element of our second certainty is the beneficial interest. Now, the settlor must be very clear exactly what share each beneficiary is to receive. Note, the exercise of a trustee's discretion in a discretionary trust would cure any uncertainty in this regard. So what we're talking about here is fixed trusts. So in a discretionary trust, the fact that a trustee has discretion means the settlor doesn't need to specify the beneficial interests. But in a fixed trust, they have to make them plain. And where the settlor fails to make the beneficial interest plain, then the property will be held on a resulting trust for the settlor. As an example of that, see the case of Boyce and Boyce. Now in this case, the testator devised several houses to trustees on trust to convey one of them to his daughter Marie, saying whichever she may think proper to choose or select, and all of the other houses were to go to his other daughter Charlotte. Now unfortunately, Marie predeceased her father. She died before her father, with the result that her gift lapsed. Now this is a standard rule in probate law, which is now enshrined in section 25 of the Wills Act. But if you are due to inherit property under someone else's will, and you die before they do, your gift is said to lapse, and therefore it reverts back to the estate of the person whose will you were due to inherit under. So Marie's gift lapsed, but her gift, of course, included a choice out of a range of properties. And so that choice was never made, that choice was never exercised. And the court held that the gift on trust to the other daughter of all of the other houses had to also fail for uncertainty, because Marie had died before her father and before making her choice. And so in effect, by failing to make that choice, she rendered her sister's interest uncertain. We wouldn't know which property Marie would have chosen, and therefore Charlotte's interest was rendered uncertain. Many comment that that decision is particularly harsh. The answer to that problem might have differed if Marie had survived her father but died before making the choice. In that instance, it may well have been possible for her executors or her administrators, her personal representatives, to deal with the issue of making the choice. But as it happens, she died before her father, and therefore, although a harsh decision, it is technically correct on the basis that Charlotte's interest was rendered uncertain by the death of her sister. As a further example of certainty of beneficial interest, see the case of Rigolet's will trust. In this case, a testator directed his executors to let his mistress, who was known as Tossie, affectionately, although one of the case books actually refers to her as Tottie, which is perhaps a better nickname for a mistress. But anyway, it was to let Tossie enjoy one of my flats during her lifetime and to receive a reasonable income from my other properties. Now, generally, you might think that reasonable income could be problematic. When we considered the issue of the bulk of my residuary estate in Palmer and Simmons, that was considered to be too uncertain. It was subjective. The bulk doesn't have an objective meaning. But here, the court took a very different approach in respect to beneficial interest. They said there'd be no difficulty in quantifying reasonable income. The prime question is whether the testator's intention was that the decision as to what was reasonable could be left for the trustees to decide. Now, if it was the testator's own personal conception of reasonable, then the trust would have to fail unless he'd issued guidance. But if it was more generic as to what was reasonable, then that would be okay. And the judge in the case took the view that the yardstick of reasonable income was not intended to be considered subjectively, but rather objectively, and that the trustees, with the aid of the court, could decide what constituted a reasonable income. Now, of course, we may have some debate over this. The word reasonable in common everyday parlance is actually quite subjective, but we know from our previous legal studies that the word reasonable is used in law as an objective yardstick. We talk of the reasonable man. And so the court here has taken a more pragmatic approach and looked at the overall intention of the settlor and given effect to it. So again, this shows a close relationship between two of our certainties. You can compare and contrast Golay with the case of Re Kolb's will trust, where the testator gave his trustees powers to invest in blue chip securities. But the term blue chip here wasn't defined by the settlor, and there was no objective definition of the term blue chip. And so there was no consensus as to which securities would fall within that. And the court there said, well, that's too subjective a description, and therefore that has to fail. And so you can see some degree of inconsistency as to the court's approach here, but it's taken on a case-by-case basis. Here on this slide, we have a graphical representation of the case of Boyce and Boyce. Now, it's a slight variation on the magic triangle that we've been considering in other examples. Here we have a settlor transferring legal title in several houses and property to trustees, but transferring equitable title to two separate beneficiaries, beneficiary 1, Marie, and beneficiary 2, Charlotte. Now the trustees owe personal obligations in respect of all of those properties towards the beneficiaries until such time as the beneficiaries select which properties they want for themselves, in which case transfer would be made of title to them. Now, if this were to work, beneficiary 1, Marie, would have made her choice, and at that stage that would have clarified which houses were left over for beneficiary 2, Charlotte. Unfortunately though, that's not what happened in the case, so let's just reset the diagram and have a look at what actually happened. Now in the case itself, beneficiary 1 died, and so no longer being in existence, we're left with a gap in our magic triangle. We don't know which property she would have taken the equitable title in. She didn't make the choice, and the trustees don't know, and this renders that interest uncertain. But as a knock-on, that also therefore means that beneficiary 2, Charlotte's interest, is uncertain. We don't know what beneficiary 1 would have chosen, and therefore how can we know what beneficiary 2 would have ended up with? And in such circumstances, the court holds that the previous equitable owner should still be the equitable owner. If we don't know what interest a beneficiary is to get, then the property has to go back to the estate of the settlor on what is known as a resulting trust, because the settlor has failed to exhaust their beneficial interest. That broadly concludes our discussion of certainty of subject matter. In the next part of the podcast, we'll be considering certainty of objects. Hello and welcome to this, the fourth and final part of our podcasted lecture on the three certainties. In our previous instalments, we've considered the general requirement for certainty, we've looked at certainty of intention, and we've considered certainty of subject matter, i.e. the trust property. We now move on to consider our final certainty, that is certainty of objects, or certainty as regards to who the beneficiaries are. According to the case of Re-Endicott, no principle has greater sanction or authority than the proposition that a trust, by English law, not being a charitable trust, must have ascertained or ascertainable beneficiaries. The principles here relate to the need for the trustees to be able to know the identity of the beneficiaries under a trust. It's important that the courts have someone in whose favour they can decree performance of the trust obligations. Apologies for that background noise, that's my cat seeking attention. It's important that the courts have someone in whose favour they can decree performance of the trust obligations, and the identity of the beneficiaries therefore has to be certain, so that the court can effectively police the performance of the trust by the trustees properly, performance of their obligations. The beneficiary is the one with the equitable rights, the equitable interest, and they're the ones who are able to bring an action as against the trustees if they are not fulfilling their trust obligations. But what level of certainty must there be as to the class of beneficiaries for a trust to be held valid? Before we come on to consider the level of certainty required, the general approach to considering certainty of objects issues should run as stated on the slide. Firstly, you need to identify the institution that we're talking about, the type of transaction, the specific type of trust or other property arrangements. Then, of course, you need to state the relevant test, and that depends on the institution we're talking about. I'll come on to define those institutions in a moment's time. You need to identify the material facts, apply the relevant test, identifying any problems that might then throw up on our facts, and conclude. So taking generally the IRAC type approach to problem solving, identify the issues, state the rule, identify the facts and apply according to the facts before concluding. In terms of the specific institutions, let's consider these on the next slide. And the institutions we're talking about when being asked to identify the institutions are as follows. Firstly, a fixed trust. And in a fixed trust, property is specified to be divided amongst beneficiaries in very precise and predetermined shares. An example given on the slide is on trust for my children in equal shares. In that trust, each child will receive the exact same amount. It's fixed by the settlor, and there is no discretion left to the trustee at all. In such circumstances, we know very clearly what each beneficiary is going to get from the outset. Contrast that with a discretionary trust, where the share of each member of a class of beneficiaries will be determined by the discretion of the trustee. An example given on the slide is 2x on trust for such of my children as X may select. Now here, we don't know exactly what share and in what proportion each beneficiary or each potential beneficiary could benefit. What we do know is that the pool of potential beneficiaries is such as my children, and that X may select any or all from that pool of potential beneficiaries. So the trustee has a discretion in this situation. It is up to them how much each beneficiary gets out of that pool, out of that class. But it's still, the trustee is still under an obligation to act, so they still have to do that. It's up to them how much each beneficiary gets, but they must decide that someone gets something. They have to exercise that discretion. Contrast that with a power. Trusts impose obligation on a trustee, which the trustee is required to perform in obedience to the terms of the trust. Any breach of such obligations will render the trustee personally liable to account to the beneficiaries for any loss that is suffered, and thus to restore the value of the trust fund if the original trust property can't be recovered. Equally significantly under a trust, the beneficiary acquires a proprietary right in the trust property, and the trustee owes fiduciary obligations to the beneficiary further to the trust. By contrast, an ordinary power, which is not in the form of a trust obligation, creates no such proprietary rights in any beneficiary, although it might impose obligations on the holder of the power. But with a power, the holder of the power, the person who receives it, the donee, if he or she thinks fit, may allocate property by exercising the power placed in his or her hands. An example would be 2x with power to select in favour of my children and in such proportions as he sees fit. Now, note usually here, a power refers to dealing with someone else's property, where the holder of the power doesn't take title to that property. They are merely given permission to exercise choices over it, whereas a trustee receives title to the property and is under a clear obligation. So the main distinction between the two institutions here is that a trust has mandatory obligations, i.e. a must do, and holds title, whereas power doesn't involve any transfer of title and is merely a permission, a may do. Now in terms then of the specific tests, let's consider each of the individual institutions in turn. And in terms of the first of our institutions, a fixed trust, you'll recall that in a fixed trust, the settlor has very clearly specified how much each beneficiary is to get under the trust. In that sense, the name is logical. Their interest is fixed. And in relation to establishing the certainty of objects, the certainty of the beneficiaries under a fixed trust, it's necessary for the trustees to be able to compile a complete list of the beneficiaries, as required by Inland Revenue Commissioners and Broadway cottages. So it must be possible to draw up a complete list of all potential beneficiaries, and the definition of the beneficiaries has to be conceptually certain. That is, if they are described in terms of being a group or a class, that description has to have a clear objective meaning, and there must also be evidential certainty of who is within the class, i.e. any potential claimant who comes along has to prove that they fit that description. So that means that the trustee must be able to name each possible beneficiary or to identify all of the members of the appropriate class. And if there are any claimants at all about whom the trustee couldn't be certain, or if the trustee isn't able to compile such a list, then the trust would be void for uncertainty as to the objects. In relation to fiduciary mere powers, the leading case is the decision of the House of Lords in Regal Benkian. Now, the Gulbenkian settlements included a power to appoint in favour of Newbargle Benkian and any wife and his children or remoter issue, i.e. that applies to grandchildren and so on and so forth, and any person in whose house or apartment, or in whose company, or under whose care or control, or by or with whom he may from time to time be employed or residing. Therefore, basically, more or less anyone he's ever met in his life at any point, a power to appoint as between that very large pool of individuals. Clearly, a complete list would have been impossible and impractical to draw up. However, the court held that it wasn't needed. They said that the point of a power is to allow the donee, the holder of the power, to make payments to individuals in certain categories, as long as they were considered worthy of it. And so they formulated a new test, known as the any given individual test, i.e., can it be said with sufficient certainty whether any given individual is or is not a member of the intended class? And they said it does not fail simply because it is impossible to ascertain every member of the class. And there is some logic to this, a power being merely a permission and therefore with a degree of optionality about it. You wouldn't expect quite so stringent a test. And as long as broadly there was someone to select from in a pool, then the holder of the power could be deemed to be able to make that selection. Moving on to consider discretionary trusts, it was once the case that discretionary trusts were treated in the same way as fixed trusts, and that they required a complete list. Now, with powers, a moment ago we saw that because of the optionality of the power, the fact that it was only permission rather than obligation, the courts were quite happy to say we don't need to know absolutely every potential beneficiary of this power. We're quite happy for the holder of the power to make the choice as long as there is a wide enough pool of people to select from. Now, with trusts, the situation is slightly different in the fact that a trustee might have a discretion as to who to select, but they are still under a formal obligation. They still have to select somebody. And so historically, discretionary trusts were treated in the same way as fixed trusts, and that you had to be able to draw up a complete list. But in the case of McPhail and Dalton, the House of Lords considered a discretionary trust which concerned a large fund for a very wide range of people who were associated with a company, including employees, ex-employees, their relatives and dependents. And clearly, a complete list of those would be difficult to draw up. But the House of Lords said, actually, that it wasn't needed. And they held that the test for certainty of beneficiaries in discretionary trusts should be similar to the test which had been accepted just a few years earlier in Regal Benkian for powers. They said that trustees should not approach their duties in a narrow way, and that they should make a survey of the range of possible beneficiaries as will enable them to carry out their fiduciary duty. So they adopted the any given individual test, i.e. it must be possible to say of any given individual that he or she is or is not within the class. And therefore they adopted a slightly more generous test. Now that wasn't the end of the story though. That case was then punted back down to the lower courts and was appealed back up to the Court of Appeal on a separate point of law, where the Court of Appeal took the opportunity to expand upon what the House of Lords had said in respect to the any given individual test. And by the time it got to the Court of Appeal, its name had become Re-Badensdeed Trusts number 2. And they took this opportunity to analyse the any given individual test, and in doing so the Court of Appeal drew a distinction between conceptual certainty on the one hand and evidential certainty on the other hand. Conceptual certainty is referred to in some of the judgments as semantic certainty, the certainty of the wording describing the class, the overall group of beneficiaries. And a discretionary trust is valid provided that the beneficiaries are defined with conceptual certainty, as long as the description that's given to the potential class is objective, then that will be fine. And a discretionary trust is not invalidated by the absence of universal evidential certainty. Now, evidential certainty refers to the extent to which, as a matter of evidence in a particular case, specific persons can show themselves to be members of the class. Now, so conceptual certainty depends on the words that have been used by the testator. Do they have a precise meaning, something clear, something objective that would be recognised by the trustees, would be recognised by the courts, and could be held to define the class that the testator intended to benefit? As an example of something that's defined with conceptual certainty, think about the term employees. There is a specific legal definition of the term employees, and therefore that would have a clear objective definition. However, a discretionary trust could be set up for the benefit of, for example, friends. Now, friends is a little bit more problematic as a descriptor of a group. Not everyone necessarily has the same interpretation of that word. Some people might think that a friend refers to only their closest of people, their best friend. Others might use it a bit more liberally to include any of their associates, colleagues, people that they socialise with, generally what many of us might call acquaintances. Some may even go as far to include the Facebook definition of friends and have 475 of them. But you'll see that it doesn't have a very clear objective definition. And so in that instance, that wouldn't be seen as conceptually certain for the purpose of a trust. Evidential certainty is different. It refers to the extent to which, as a matter of evidence, people can show themselves to fit that description. And as long as the description itself is clear, you don't need absolute universal evidential certainty. You don't need to be able to draw up a complete list of everyone who fits that description, as long as the description itself is clear. And the majority of the Court of Appeal in Baden said it didn't matter if significant numbers couldn't be classified, provided that there are a substantial number who can definitely be identified as being within the class. So the thing that's important with a discretionary trust is that the label given to the class of beneficiaries, the potential pool of people who could benefit, is objectively clear. It's a term that we can understand. And in Re-Baden itself, the Court of Appeal held that the terms relatives and dependents were not conceptually uncertain. Note the double negative there. In other words, they were conceptually certain. They felt relatives and dependents could be objectively defined. But we run into problems with terms like friends, which are much more subjective as descriptions. Continuing with certainty of objects, part of the requirement that the objects of a trust be certain is a requirement that the trust is drafted in such a way so that it's possible to administer the trust physically, and in such a way that the courts can then judge whether or not administration has actually been carried out properly afterwards by the trustee. And in the district's auditor's case on the slide, a trust which would have had the effect of including within its class of beneficiaries 2.5 million people in West Yorkshire was held not to be drafted in such a way. It was held not to be administratively workable. So a discretionary trust will be invalid if it's administratively unworkable because of the sheer size of the class of potential beneficiaries. If it's too wide, it becomes unreasonable for lay trustees, generally speaking we're talking about 1 or 2 people here, to undertake a survey of 2.5 million people. And it's also then unreasonable for a court to consider whether or not they've done their job properly when potential trust benefits so many people. And so in the case itself, the trust would have included seeking to relieve unemployment in the region, assisting bodies that worked with problems experienced by young people, and the encouragement of better race relations. It was held that these objectives might arguably be considered more suited to a charitable trust, but coupled with such a broad geographic region and such a large body of beneficiaries, as a private trust, it becomes administratively unworkable. It's not possible to actually physically run the trust. It becomes so great a task that it ought to be declared invalid. And this is considered to be part of the requirement for certainty of objects. If you define your class so broadly as to take in too many people, then it's administratively unworkable, but that renders your objects uncertain as well. And where a trust fails for uncertainty as to the objects, then there is a specific consequence which flows from that. And again, we revisit our magic triangle. When you fail to specify beneficiary, you leave a gaping hole in the magic triangle, and the trustee doesn't know for whom they are holding property, and we don't clearly have anyone who is owning the equitable title at all. And so in that circumstance, equity sees that as a problem, and it's commonly said that equity abhors a vacuum in ownership, that is, inequitable ownership. And in such a situation where a settler has failed to specify the new equitable ownership, they have failed to divest themselves of their equitable interest. And in such circumstances, equity dictates and mandates that the equitable interest has to revert back to the settlor. They haven't exhausted their own beneficial interest, therefore it has to revert to them. And so when a purported trust fails for certainty of objects, the trustee is required to hold the property on a resulting trust for the settler, i.e. the interest results back to the settler or their estates if they are now deceased. Some attempts sometimes have been made by settlors to try and resolve uncertainty, to try and anticipate potential problems with certainty of objects. And we're looking here at situations in which provisions have been added to the trust instrument to enable the trustees to resolve any uncertainty by reference to experts or other designated individuals. And where settlors have provided that some expert party should be able to adjudicate on those persons who will or will not fall within a class, that has been considered acceptable in finite circumstances. In Reed Tuck settlement, as an example, Lord Denning held that a trust where money was left for the benefit of such of the testator's children who married into the Jewish faith would be valid where the court, or rather the trustees, was able to ask the chief rabbi for advice as to the extent that there might be uncertainty about any particular claimant who came along. And similarly in Blathwaite, a condition that the claimant must remain Catholic was accepted as being sufficiently certain. Again, you could decide that by reference to a priest or a bishop as to whether someone remained Catholic. But note, in both of those cases, the actual term itself was something which had an objective definition which could just be clarified by some expert party, and that they could resolve the point of evidence as to whether someone was either of the Jewish faith or had remained Catholic. Compare and contrast that with the situation at the bottom of the slide, where attempts have been made to give the trustees themselves a power to decide who will or will not fall within the class in the event of any alleged uncertainty. And this has been seen as more problematic. Justice Jenkins dismissed the general effectiveness of such provisions in the case of Reed Coxon. A concept, here in this case old friends, was not made certain by leaving it to the trustees to decide who constitutes an old friend. Firstly, there's no clear criteria on which the court can review the trustee's decision in the event of challenge from a potential beneficiary. And secondly, the court will typically be unwilling to allow those acting as trustee to effectively step into the shoes of the settlor and clarify what the settlor meant in the first place. And so the court said there wasn't an objectively clear meaning to old friends here, and it's not okay to allow trustees to decide it. Nor would it be okay with something so subjective to try and appoint an expert party. How do you have an expert party over something which is so subjective? And arguably the two cases at the top deal with only resolving points of evidence, not problems with the concept itself. Also, in the case of rewrites will trusts, a transfer of property was made to trustees to help institutions which they considered had helped the testator during his lifetime. So again, giving the trustees the power to decide who they thought had helped the testator. And that transfer was held to have been uncertain for the same reasons that there's no objective criterion on which the court could evaluate the effectiveness or the appropriateness of a trustee's decision. So generally speaking, resolving uncertainty is only possible where you're talking about something which has a clear objective meaning, i.e. is conceptually certain, but where you might have a problem of proving that a certain person meets the general criteria on that, and an expert could adjudicate on that. It doesn't work to allow trustees to actually decide what the settlor meant in the first place. Now, put the note there to compare and contrast with a series of individual gifts. On the previous slide, we were talking about old friends being uncertain, and the example I gave earlier as well was friends very generally. Now, the situation we've been describing has all been to do with trusts specifically. Now, trusts are different to gifts, and where you have a series of individual gifts which are subject to a conditioned precedent, then the same standard of certainty need not be applied. Now, gifts subject to a conditioned precedent are gifts of fixed amounts to each person who satisfies the description of beneficiaries which are set out in the will or other documents. And satisfying the description of the beneficiaries is the conditioned precedent. So that's a gift subject to a conditioned precedent. An example would be £5,000 to each student passing their equity exam in the summer. I would add a disclaimer here that that's not a promise, but it's an example. So £5,000 to each student passing their equity exam in the summer. Now that would be the conditioned precedent, and it'd be an individual gift of £5,000 to each person who met that condition. Contrast that with a trust, particularly a fixed trust. The beneficiaries of a fixed trust share a common pool of money or property. Conditioned precedent gifts give individual amounts or assets to each beneficiary, and by reading the gift you know exactly how much each beneficiary will receive, and in such cases the courts are happy to apply a lower standard of certainty with regard to the objects. As an example, see the case of Rebarlow, where paintings were given to a local authority with instruction to allow family and friends each to purchase a painting at a fixed price. That fixed price being a reduced price, therefore the nature of the gift being a discount. It would have failed as a trust because the term friend, as we've seen, has no conceptual certainty. But bearing in mind that there wasn't this common pool of property, and that there were no ongoing obligations on the part of a trustee, it was just a case of satisfying a description and then being entitled to something. As a series of gifts, the court said a lower standard of certainty was required, and there's no need to survey the class as there is with a trust. You just assess any individual claims as they come along, as people claim to be family or friends wanting one of these paintings. You assess them on a case-by-case individual basis, which is not the duty of a trustee. So only if you have an example similar to this, a gift subject to a condition precedent, you have a lower standard of certainty to apply. So, by way of a brief recap on certainty of objects, starting with fixed trusts, that is, trusts which have a clearly predetermined and defined interest for each beneficiary, we need a complete list. We need to be able to name every single one of the beneficiaries and identify them. And for fixed trusts, we need conceptual and evidential certainty. This is quite logical. If the interests are fixed and predetermined, then the job of the trustee is fixed and predetermined, so they need to know exactly who they're acting for. With discretionary trusts, it's the any given individual test. Can it be said with sufficient certainty whether any given individual is or is not a member of the intended class of beneficiaries? And you'll note the cases of McPhail and Reed-Baden. Here, the important element is conceptual certainty. The description that's given to the intended class has to be something that is objectively understandable, something that the trustees and the courts would agree on. So careful of terms which could be subjectively understood, such as friends, but with terms that can be objectively agreed, then we should be okay. Also note the possible concern about drafting the class too widely so as to encompass too many people. That would then render it administratively unworkable. But provided the class is sufficiently small and is objectively defined, then that should be fine. With powers, the test is the same as with discretionary trusts. We need conceptual certainty there. And with a conditional gift that we just saw a moment ago, the condition is valid for those who prove they satisfy it, and we have a lower standard of certainty. In terms of approaching problem questions in this area, and you may well have noted that this particular area would lend itself quite well to problem questions, then you should deal with each certainty in a logical order, even where there are no problems at all. So if you identify immediately that intention is fine, still say so. Identify that it complies with the requirements of Wright and Atkins, that the intention has to be imperative, it's mandatory. Note that you have considered the issue, and then move on to the next certainty. Deal with subject matter, deal with both subject matter as a whole and with regards to the beneficial interest. Note, of course, in a discretionary trust, you don't have to deal with that second sub-element because the trustee's discretion deals with that particular issue. And of course, finally, deal with who the beneficiaries are. State the relevant test depending on the institution you're talking about, and apply it to the fact before you. The one thing that people commonly forget, though, when dealing with problem questions, is the effect of any uncertainty. They're commonly quite happy to say intention is problematic, or subject matter is an issue here, and then leave it. Now that, as an answer to a question, is insufficient, it's incomplete, and in real life, if you were advising a client, the client would say, and so what next? And so you need to make sure that you talk about the effect of uncertainty. So it's not sufficient just to end an answer with the decision as to whether or not there is certainty. You must then go on to say what the effect of any uncertainty will be. So just a brief recap, with intention, if something fails solely on certainty of intention, then the recipient of the property, who would have been the trustee, takes the property absolutely, beneficially, as a gift. They hold it free from any trust. And that's because property has been transferred to them, but no obligations have been fastened on top of that. With subject matter, if it's as a whole, the entire transaction is said to be negatory, i.e. of no effect whatsoever. And the settlor or testator remains the owner of the property. There's no question of a resulting trust. You can't have a resulting trust of uncertain property any more than you can have an express trust or gift of uncertain property. Nothing was ever identified to leave the estate, therefore it is still part of the estate. The exception to this outcome is if it's found that the purported trust has been attached to a gift in the first instance, in which case the gift takes effect, and see the rule in Hancock and Watson and the case example of Strange and Barnard for such an instance. With beneficial interests that are uncertain, there is a resulting trust for the settlor or for the testator's estate as appropriate. In the latter case, the property will go to the residuary legatee, the person named as as benefiting from the residue in the will, or if there is no residuary gift, then it would go on the intestacy rules to the next of kin. With objects, it's treated in exactly the same way. It's a resulting trust for the settlor, the residuary legatee, or the next of kin as appropriate. But make sure you do in fact deal with the effect of uncertainty when dealing with problem questions. Only that way can you give complete and comprehensive advice. And finally, is this certain? A large part of my estate to Manchester Metropolitan University, hoping it will be used to benefit overworked law students who have trouble staying awake in equity lectures. I'll let you digest that for a brief moment, but hopefully very quickly you should be able to identify one or two problems based on our foregoing discussions. So, a large part of my estate. That sounds like an issue of subject matter. It's very similar to bulk. What constitutes a large part? We don't know. So it's a bit like Palmer and Simmons. Hoping it will be used? That sounds precatory in nature. So again, we're not clear on another certainty, intention in this case. Overworked law students? You might have some issue of conceptual difficulties there. As overworked might not necessarily be objectively understood, although I'm sure I would agree that law students are overworked. But the final bit, who have trouble staying awake in equity lectures, surely there is no such concept there. Surely there is no such person who has trouble staying awake in equity lectures. You get the idea. So this concludes our podcasted lecture on the three certainties. In our next podcasted lecture, we'll be looking at constitution of trusts.